Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. Alright, here's a quick favor you can do for yourself. If you're even thinking about your case management setup, go take a look at this. E-Immigration is offering listeners of this podcast a free demo, and when you book through the link in the show notes, they'll donate $25 to Casa Cornelia Law Center. And yes, there's a bonus. Everyone who signs up will also get a free upgrade from the Essentials package to complete. It's a win-win. So go to get.eimmigration.com/IRP, check out a ton of free resources, and book your demo today. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, folks. So many decisions. A massive week of cases. And I rarely do this, but due to personal circumstances, I recorded Wednesday evening. And already by then, there were 8 cases. 8! Lord knows what the ultimate total is going to be. Because I'm not doing the Thursday and Friday cases. If you hear them, you'll be hearing none other than former BIA member Homero Lopez subbing in on those decisions. Might we have a former BIA member review a BIA decision? Time will tell, you lucky skunks. Good luck, Homero. But for the first 8, you have me, as always. By the way, if you don't hear Homero, it's because nothing was published on Thursday or Friday, or because disaster struck and we're pushing cases to next week. The risk you take of listening to a free podcast. Also this week, our TPS case went to oral argument with Syria's as well, but really, all of them are on deck because it's going to get decided on jurisdiction. Ahilan and Jeff did great, of course, and to the Solicitor General's credit, he's not playing hide the ball. He told the justices exactly what he and the administration want. No review, pretty much ever, as horrifying and undemocratic as all that sounds. Not to mention inconsistent with decades of Supreme Court precedent. I don't know how the court will rule, and I've stopped trying to guess such things. We and all the TPS teams left it all on the table. The decision will be discussed on a future podcast. Enough of that, we've got enough this week. And so it is now my pleasure to provide you with these God knows how many cases. Our first case is Barbosa de Cunha v. Freden, published by the Second Circuit on April 28, 2026. Let's rock and roll, folks. The circus split on mandatory detention for EWIs has arrived. The Miller folks at the BIA got their wish. Supreme Court next term for sure. This bad boy is 69 pages and ain't really double-spaced either. This is why you tuned in this week. So here we go. Mr. Barbosa de Cunha is from Brazil and has lived in the United States for more than 20 years. He entered the United States without inspection or admission. He owns a home in Massachusetts, is married, has 2 U.S. citizen children, and has never been convicted of a crime. He's had an asylum application pending with the U.S. government for quite some time, an affirmative application, it appears, so he's not really hiding. The Department of Homeland Security arrested him on his way to work in 2025 for no discernible reason other than to be cruel to non-citizens and get their numbers up. Would have been an easy bond before matter of Hurtado and probably a kind of perplexed IJ. But of course, the BIA changed the rules last year and took the position that no EWIs, none of them, can even get a bond hearing. So Mr. Barbosa de Cunha sued like so many thousands like him and got a bond hearing. Got a habeas petition granted in federal court where the judges are not worried about getting fired, and when an IJ was ordered to grant a bond hearing, lo and behold, the IJ ordered release on bond after looking at Mr. Barbosa de Cunha, the human being. The U.S. government appealed the habeas grant. The Second Circuit notes that the lives and liberties of literally millions of human souls are on the line. The Second Circuit affirmed the district court and created a circuit split with the Fifth and Eighth Circuits. The Second Circuit believes that the plain text of the statute at issue demands this result. So do the Fifth and Eighth Circuits, so someone's got to be wrong. But you know what? The Second Circuit's decision is longer, so it must be right. Also, the Seventh Circuit is on the Second Circuit's side, at least preliminarily so, notes the court. That's Castañón Nava v. DHS. Before getting into the weeds, the Second Circuit notes, quote, our holding is consistent with the decisions of over 370 district judges across the nation who, as of mid-February 2026, have also rejected the government's position, end quote. That's over 90% of district court judges, explains the Second Circuit. Thank you, AILA and AIC, for providing that statistic to the court. If I&A Section 236A applies, EWIs get a bond hearing. That is, those who entered without inspection and admission. The text of that statute, kind of ignored by the Eighth and the Fifth Circuits, reads that, quote, on a warrant issued by the Attorney General, a non-citizen may be arrested and detained, pending a decision on whether the non-citizen is to be removed from the United States, end quote. Fair enough. And removal proceedings cover both those charged as inadmissible and those charged as deportable, post-IRIRA. That is, no matter whether the charge travels under I&A Section 212 or 237, the question is the non-citizen to be removed from the United States? Same question, explains the Second Circuit. For such people, that is, Section 236A people, and the people that we're trying to figure out whether they're going to be removed or not, subject to exceptions not applicable here, DHS, quote, may release the non-citizen on bond, end quote. So explains the court. Absent exceptions not applicable here, all people in removal proceedings can get a bond. Mr. Barbosa de Cunha meets all these requirements. He, 1, was served with a warrant issued by the Attorney General, 2, is a non-citizen, 3, is subject to a decision on whether he is to be removed from the country, and 4, isn't subject to the mandatory detention grounds of the I&A. Now, the government argued that Section 236A only applies to those who enter lawfully and overstay their visas, but Section 236A doesn't say that, explains the court. Like it all. Rather, at the court, the question is the non-citizen in removal proceedings, quote, pending a decision on whether the non-citizen is to be removed, end quote. If so, Section 236A bond applies. That's the starting point for the Second Circuit. I&A Section 235B2A is the exception, and it doesn't apply here. That's the thing about applicants for admission. The Eighth Circuit and the Fifth Circuit say once an applicant for admission, always an applicant for admission, and so too for mandatory detention. And I shall not do their summaries again, but check out episodes 309 and 303 if you're curious. But we got to distinguish 235B2A. That's really the whole game. Hinges on applicant for admission, and the term admission is defined in I&A Section 11813A as, quote, the lawful entry of a non-citizen into the United States after inspection and admission, end quote. And the term entry is commonly defined by dictionaries to be the, quote, act of entering, end quote. The Supreme Court also long ago said that, quote, entry by its own force implies a coming from outside, end quote. Similarly, the term seek, used in the Section 235 statute, means requesting or to ask for and implies present action. Putting it all together, the mandatory detention provision at INA Section 235b2a to the Second Circuit, quote, applies only to 1, non-citizens who are present and have not been admitted, and 2, are requesting 3, lawful entry into the United States after inspection and authorization, end quote. Here, although Mr. Barbosa de Cunha remains an applicant for admission technically, he's not presently seeking admission, and he's not requesting lawful entry in the United States. Who does Section 235b2a detention apply to then? Well, thanks to the Supreme Court's Orozco decision, it, quote, applies to those non-citizens who present themselves at a port of entry for admission or who cross the physical border in the United States but are apprehended at the threshold of initial entry, end quote. I wouldn't be surprised if Justice Alito, who authored the Orozco, thinks that it applies to more people too, but I guess we'll find out next term. To the Second Circuit, you're not seeking forever, contrary to what the BIA, Fifth Circuit, and Eighth Circuit would have us believe. Nor is seeking admission in the statute just redundant and another way of saying applicant for admission, as those courts would also have us believe, explains the Second Circuit. Quote, to the contrary, he evaded immigration inspectors, snuck into the country, and today applies only for non-admission forms of relief, including asylum and cancellation of removal, end quote. The forms of relief you apply for when you haven't been admitted to the United States. That seems about it to me. I would say that, but we still have 50 pages to go. 50 pages! I won't do them as in-depth as I just did all that. But I mean, it's a lot, friends, and I warned you about this week. Much of those 50 pages is just reciting the BIA, Fifth Circuit, and Eighth Circuit, and government's alternative rationales and arguments. So really just listen to the Fifth and Eighth Circuit summaries, says I. Here are some of the highlights, though, of the Second Circuit's rejections. Remember that college admission hypothetical made by the Fifth Circuit and then relied on by the Eighth? Well, quote, it is precisely because Congress employed a statutory term of art for applicant for admission, but not for seeking admission, that the analogy to an applicant for college, relied upon heavily by the government and our two sister circuits, is an opposite, end quote. It's not the same admission because Congress actually defined a phrase here, unlike college admission. And, quote, even sticking with it, though, for the college analogy to make sense here, a college would have to deem an individual physically located on its campus at any point in time to be an applicant for admission to that college, including an individual who had never filed an application and had no intention of doing so. But giving applicant for admission such a technical meaning would not automatically affect the ordinary meaning of seeking admission merely because the two phrases appear similar, end quote. Shots fired, Second Circuit. Couldn't have said it better myself. And I tried and failed, so thank you, Second Circuit. This one's even better to me. Quote, here's a better analogy. If someone sneaks into Yankee Stadium at the start of the game with no ticket for admission and no intention of ever paying, and he is later found by security in a seat in the 7th inning, no one would consider that fan to be seeking admission to the game, end quote. The court goes through so much stuff, including other IRIRA provisions and their interplay. Give it a read if you're curious before your court or the Supreme Court rules, or if you need to brief a Habe. Now, honestly, reading the other INA provisions, the INA is just a mess, everybody. It's just a mess, but we all know that. The Second Circuit believes the Supreme Court's discussion in Jennings supports this finding, given its statement that Section 235 operates, quote, at the nation's borders and ports of entry, where the government must determine whether a non-citizen seeking to enter the country is admissible, end quote. While Section 236, quote, authorizes the government to detain certain non-citizens already in the country, pending the outcome of removal proceedings, end quote. And well, quote, to the extent that the government alternatively attempts to downplay the language in Jennings as mere dicta, it is well settled that we are obligated to accord great deference to Supreme Court dicta, absent a change in the legal landscape, end quote. To hold otherwise and to treat the Mr. Barbosa de Cunhas of the world like the non-citizen who was caught immediately after coming in the United States is to stretch the statute and the Orozco logic to the point of impossibility, explains the court. Makes portions of the Laken Riley Act superfluous, given that that statute made only a subset of EWIs subject to mandatory detention. So that doesn't make sense, right? Nor does the Second Circuit believe that IRIRA legislative history is on the government's side, particularly where the text isn't on their side either. Quote, indeed, the government's use of legislative history illustrates the worst pitfalls of that method, derided as looking over a crowd and picking out your friends, end quote. Selective legislative history analysis coming from the government reasons the court. And then we've got that 30 years of executive practice not interpreting the exact same statute in this way. Not definitive, but also not nothing, reasons the Second Circuit. For many reasons, quote, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism, end quote. Absolutely love that, not gonna lie. And then Congress didn't correct this alleged misinterpretation for over 25 years? And when they did do something, it was Laken Riley only making some EWIs subject to mandatory? Come on, guys, says the court. Quote, where an agency has long failed to reach for a power and only later changes its mind, we may consider that as persuasive evidence that the power was never conferred in the first place. End quote. Man, that quote just applies to so much in immigration these days, doesn't it? This is big deal stuff and Congress is just silent? Quote, the government's interpretation would send a seismic shock through our immigration detention system and society, straining our already overcrowded detention infrastructure, incarcerating millions, separating families, and disrupting communities, end quote. Seems like that's something Congress would have been clear about, right? And can you believe that a faction of America desires that? That's just a policy point, and that's me, not the Second Circuit. This is not just cramming an elephant into a mouse hole, as I believe the Eighth Circuit judge in dissent discussed, but, quote, given the enormous consequences of its interpretation and the vast breadth of our nation's immigration laws, the government here seeks to cram a veritable legislative zoo into an exceptionally small mouse hole, end quote. This issue really brings out the analogies and metaphors, doesn't it, folks? Finally, even if there was some statutory ambiguity and the court doesn't see it, the canon of constitutional avoidance would sway the Second Circuit away from wrecking the lives of millions of people by throwing non-dangerous, non-flight risk human beings who have been in the U.S. for decades behind bars, potentially indefinitely. Civil detention, after all, must be, quote, non-punitive in purpose and effect, end quote, to comply with the Fifth Amendment. And with the backlogs and everything, Mr. Barbosa de Cunha will likely be behind bars for a long time, believes the court, absent a bond hearing. Going back to its pretty awesome Velasco-Lopez decision from episode 27, the Second Circuit explains, after all, that, quote, the core of our decision was that detention without justification serves no public interest that could outweigh the substantial harm it causes to detainees and the community, end quote. A lot more on this constitutional stuff in this decision, but you get the point. Non-citizens are human beings too. Believing the government and certainly the BIA are trying to muddy the waters, the Second Circuit cleaned itself in the warm soapy suds of clear statutory text and constitutional protection. Okay, I went too far with that metaphor, but I couldn't help it. I was just so inspired. With all of that, you know there are a lot involved. So congratulations, Michael Keitay-Tan of the ACLU and a lot of other ACLU attorneys and offices as well. Lots of big and mid-size and other law firms on amicus, AIC and ALA on amicus as well. Names and names and names of people all fighting the good fight to protect human liberty. And how about some concurrence? Judge Cabranes joined the entirety of this decision. Judge Cabranes reiterated many points and also said this new thing that I've never seen that does seem quite persuasive to me, if one wants to understand what Congress thought it was doing in 1996. Quote, one last fact is telling. In 1996, Congress mandated the detention of certain non-citizens, mostly criminals, under I&N Section 236C. At the time, Congress knew that immigration detention facilities had around 8,500 beds, enough to detain some 100,000 non-citizens yearly. That might have been inadequate in light of the new detention mandates. So Congress gave the Attorney General 2 years during which certain non-citizens could be released while 500 beds were added. Notably, Congress allowed no such grace period for the mandatory detention of the 2 million non-citizens that the government now says then came within Section 235B2's sweep. That discrepancy is inexplicable. End quote. Which is why the government and the BIA are wrong. And that is Barbosa de Cunha v. Freden. All right, guys. 2 from the BIA this week as of Wednesday evening, and if any more are published, Omero's probably going to do them. First one being Matter of Shentu, published by the BIA. This case is about bond. Miss Shentu is from China and was charged as removable as a non-citizen who entered with a non-immigrant visa but overstayed. DHS decided to detain her, and even the BIA's novel interpretations of the INA couldn't prevent her from getting a bond hearing, which she got, and an IJ ordered her release on $7,500 bond. DHS despises it, likely because at the bond hearing, DHS got its hands on a, quote, FBI Letterhead Memorandum, end quote. Not an official FBI report, not an FBI officer's sworn affidavit, and certainly not an FBI officer's actual testimony. Rather, it's a letter that the FBI provided relaying that Ms. Shentu, quote, represents a national security risk and should remain in detention, end quote. Unsigned, I believe, as well. How quaint. The BIA loves that and sent the matter back. Found nowhere by statute explains the BIA non-citizens have the burden to show that they warrant release from detention. They have the burden. Unlike in nearly all other areas of law where human liberty is taken away, the default at immigration appears to be non-liberty. Now, it's true. Non-citizens deemed national security risks should not be released on bond. We can all agree with that. So the BIA exercised its de novo review. Everything is de novo review to the BIA these days, isn't it? And decided that that's probably what Ms. Shentu is, a national security risk. Again, even though the FBI letterhead wasn't signed by anyone and is of course unsworn, it's reliable enough for the BIA. Is it that hard to get an actual official FBI document, guys, for a national security risk? Isn't this nuts? Hearsay and lots of other protections don't apply in removal proceedings. Evidence is okay, so long as its admission is, quote, fundamentally fair, end quote. How is an unsigned hearsay document fundamentally fair? Well, you need to understand that, quote, public officials are presumed to perform their duties properly, and that records made by public officials in the ordinary course of their duties carry strong indicia of reliability, end quote. BIA, I've been led to believe you do not like circular reasoning. Or is that only with particular social groups? And how do you combat this, guys? Something right out of 1984, quote, while the respondent disagrees with the FBI letterhead memorandum and asserts that it's based on undisclosed intelligence, anonymous sources, and ethnic suspicion, rather than on actual evidence, she has not carried her burden of establishing that the evidence was inaccurate, obtained by coercion or duress, or otherwise fundamentally unfair to admit, end quote. Quote, given the government's compelling interest in addressing national security threats, bond proceedings may consider investigative assessments relating to that risk, end quote. All that means it can get admitted in immigration proceedings, fine, which the IJ did here too, so query why all the discussion. The BIA's beef is really with the weight the IJ gave to it. The BIA doesn't really explain why either, other than implying that this is a national security thing, so it's serious, folks. The BIA just kind of says stuff. Quote, an FBI letterhead memorandum indicating that the respondent's a potential national security risk warrants significant weight in bond proceedings, end quote. The FBI says there's an ongoing investigation. Couldn't muster up so much as an FBI officer's name to stand behind the statement, and of course there's no criminal arrest or anything, but it's due significant weight, says the BIA. Essentially making Ms. Shentu prove an impossible to prove negative, the BIA found that she did not meet her burden. Refusing to give her a second chance to do so, the BIA ordered Ms. Shentu remain detained without bond. Seems like DHS invoked the regulatory non-release rule that federal district court judges have deemed unconstitutional, so she's not getting released because I guess she never was in the first place. And that is matter of Shentu. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. We've also got matter of Orozco Becerra and Orozco Becerra this week, published by the BIA. It's another case about in absentia removal, and another case with pro se non-citizens. IJs can't administratively close removal proceedings when a non-citizen doesn't show up. Gotta go in absentia. Absent that very limited exception from a couple months ago where DHS doesn't show up and doesn't submit anything beforehand. The BIA doesn't usually accept interlocutory appeals, it explains, unless it's going to overturn an IJ's administrative closure order. Or maybe a continuance grant? The respondents are two children from Mexico without an attorney who did not show up to their removal hearing and did not file a brief to the BIA, explains the BIA, these children. They came with their mother, though, who was served with the notice to appear that had the date, time, and location of the first hearing. When the children didn't appear, the IJ reset the hearing. They didn't appear for the second one either, though. Deeming the evidence submitted by DHS insufficient to establish alienage, the IJ did DHS a solid and didn't terminate proceedings, but instead reset for a third hearing. More evidence submitted, and when they didn't show up for the third hearing, the IJ ordered the adult mother removed in absentia but administratively closed the case for the children. Quote, concluding that they could not be held responsible for their mother's failure to appear, and that entering an in absentia order of removal would violate their due process rights. End quote. Not so, explains the BIA. The statute puts a mandatory duty on IJs to go in absentia when non-citizens receive proper notice of the hearing, explains the board. Now, the new regulations do permit IJs to administratively close proceedings and give them quite a lot of authority to do so. That's 8 CFR section 1003.18c. But IJs can't do it when that duty conflicts with a mandatory statutory obligation, including one that the BIA has only very recently recognized. In a footnote, the BIA makes the extraordinary observation that it also has authority to determine whether the regulations it doesn't like violate the INA. The BIA really hates those Biden-era regs, doesn't it? Why not just call a spade and try to vacate them, DOJ? Just get the fight out in the open at this point, I say. Let a federal court decide whether you're allowed to do it. Anyway, gotta go absentia, holds the BIA. As to the fact that they're minors, well, apparently, in the 2002 decision matter of Gomez, the BIA, quote, rejected the argument that it would violate a minor respondent's due process rights to penalize her for failing to appear when a responsible adult received proper notice of the hearing, end quote. Congress didn't include that exception, after all, in the statute, reasoned the board there. Service on the mom cut it here to the BIA, and she was responsible for making sure the children appeared. Should an absentia order be in error, including if it conflicts with one of the many uncited Ninth Circuit decisions in this area, the non-citizens here retain the remedy of filing a motion to reopen. Reasons the BIA. Unsure if the IJ is even on the bench anymore in this wasteland that I understand the San Francisco Immigration Court to be, but if they are, they're getting the case back on remand and probably need to order the children removed in absentia. And that is a matter of Orozco Becerra and Orozco Becerra. Moving on with Nimaga v. Blanche, published by the 7th Circuit on April 29, 2026. This case about motions to reopen. Mr. Nimaga is from Mali and the Ivory Coast. Looks like he might have violated his student status and was put in removal proceedings. Quote, meanwhile, on November 8, 2016, while Mr. Nimaga's case was pending before the immigration court, his U.S. citizen spouse had been arrested for domestic violence after she struck Mr. Nimaga over the head with a large sack of paper and attempted to stab him with a kitchen knife, end quote. She eventually pled guilty to criminal recklessness. Mr. Nimaga applied for a U visa as a result, as well as VAWA cancellation of removal in immigration court. Then counsel withdrew from representation. Mr. Nimaga lived in Indianapolis, but his next hearing was in Chicago. He made arrangements to get driven to Chicago for this hearing by his friend, with his backup plan being a Greyhound bus ticket. But 2 months before the hearing, in August, he was robbed of all his money and he couldn't get another job. He had been working at a fair. And then after the robbery, no one would hire him because his work authorization was about to expire. He said he was about to go hungry by September. This hearing is going to be in October. Pro bono counsel said that they couldn't help when he reached out. Then the friend didn't come through with a car. As you may guess, Mr. Nimaga didn't then have the money for the Greyhound bus. He even asked his ex-wife to drive him, the one who tried to stab him. A neighbor tried to help too, but was not able to. No one could help. Mr. Nimaga ended up not appearing, although oddly to the 7th Circuit, that attorney who withdrew did. Ordered removed in absentia, Mr. Nimaga timely filed a motion to reopen within 180 days, arguing that he missed the hearing due to exceptional circumstances as the statute provides. An IJ disagreed, and the BIA agreed with the IJ, and the Seventh Circuit affirmed that. Statutorily speaking, for this kind of motion to reopen, exceptional circumstances are defined as, quote, exceptional circumstances, such as battery or extreme cruelty to the non-citizen or any child or parent of the non-citizen, serious illness of the non-citizen, or serious illness or death of the spouse, child, or parent of the non-citizen, but not including less compelling circumstances beyond the control of the non-citizen, end quote. Got to look at everything in entirety, too, explains the Seventh Circuit. Quote, among other factors, the agency will consider the petitioner's supporting documentation, his efforts to contact the immigration court, and his promptness in seeking relief from the order of removal, end quote. But, quote, courts have concluded that a variety of obstacles to a petitioner's attendance do not qualify as exceptional, including experiencing car trouble, encountering unexpected but foreseeable traffic and parking difficulties, general claims of illness, and misunderstandings about the date of the court hearing, end quote. But see, Montejo Gonzalez out of the Ninth Circuit in Bonk, episode 302, notes the Seventh Circuit in a footnote. Summing up the case law as the Seventh Circuit sees it, quote, obstacles to a petitioner's timely attendance at a hearing that are foreseeable, encountering traffic delays or parking difficulties, mundane, non-severe illness, or in some way attributable to the petitioner himself, misunderstandings about the hearing date or time, will likely not qualify as exceptional circumstances, whereas obstacles that were truly unexpected and beyond the control of the petitioner may so qualify, end quote. Reasonable minds could differ about whether Mr. Nimaga's case qualifies, explains the court. After all, when, right before the hearing, the friend said he actually couldn't help, Mr. Nimaga was essentially in the same position as a non-citizen whose car breaks down or who encounters exceptional traffic delays. But Mr. Nimaga could have contacted the immigration court, explains the Seventh Circuit. Good luck with that, but yes, technically possible, I guess. Could have contacted his former counsel, too. Could have tried to get a video hearing. Particularly as all this occurred hours before the hearing, and in the case of the lack of money, months. This is all not close enough to say a close family member getting ill to the court. Comes down to this, to the sympathetic court, quote, for a person with limited financial means and without a robust support network of family and friends, an unexpected event like a burglary or a ride falling through at the 11th hour can pose insurmountable obstacles to getting himself to an out-of-town hearing on time. But given that Mr. Nimaga did have the means to contact the immigration court on the day of the hearing to report his predicament and failed to do so, we cannot say that it was an abuse of discretion for the IJ and the BIA to find the difficulties confronting Mr. Nimaga were not exceptional, end quote. Seeing no abuse of discretion, the Seventh Circuit affirmed the denial of the motion to reopen. That said, the court does want to know what's up with that U visa adjudication and will postpone issuance of a mandate until it's satisfied on that issue. So there's some light for Mr. Nimaga, however dim. And that is Nimaga v. Blanche. Next is Oxlaj-Perez v. Blanche, published by the Sixth Circuit on April 29, 2026. 3 cases published by the Sixth Circuit on April 29, 2026. This case is about the 30-day deadline to petition for review. Unfortunately, the facts don't matter all that much. Mr. Oxlaj-Perez had his asylum claim denied by the immigration judge and then the BIA, and then didn't petition for review for over a month and a half thereafter. That's a problem because the statute itself, I&N Section 242b1, says that you must petition for review within 30 days of the final administrative order. Most, if not all, courts once held that that's a jurisdictional rule. But after Riley, it's not anymore. Shentu Sakaria, too, probably. Because it's not jurisdictional, explains the Sixth Circuit, it could be subject to equitable tolling. That is, the 30-day deadline to file a petition for review. But not a foregone conclusion that equitable tolling applies. That said, quote, it is Hornbook law that limitations periods are customarily subject to equitable tolling, end quote. Hornbook! Bring me back into ye ivory tower. Here, permitting equitable tolling is not contrary to the statutory scheme as a whole, so it's permitted. This is particularly so as the, quote, immigration system is one where laymen, unassisted by trained lawyers, often initiate the process, which weighs in favor of equitable tolling. So a win for the laymen. And by the way, you don't need to argue about equitable tolling of the 30-day deadline in your opening brief, apparently, although it's probably recommended. As oil has the burden to assert the mandatory claims processing rule of timely filing, Mr. Oxlaj-Perez, quote, was not required to make an argument for equitable tolling of the statutory deadline until the government asserted that his petition for review was untimely, end quote. Interesting. Pages and pages of rejecting oil's counterarguments didn't leave much space to explain why equitable tolling was not ultimately warranted in this case, despite it being less than 2 months that needed to be equitably tolled. Equitable tolling always requires a showing 1, quote, that he has been pursuing his rights diligently, and 2, that some extraordinary circumstance stood in his way and prevented timely filing, end quote. In the Sixth Circuit, then, diligence becomes a 5-factor analysis. Those factors are 1, the lack of notice of the filing requirement, 2, lack of constructive knowledge of the filing requirement, 3, diligence in pursuing rights, 4, the absence of prejudice to the government, and 5, the reasonableness in remaining ignorant of the legal requirement for filing his claim. Here, it pretty much came down to a claim of ignorance and lack of education for Mr. Oxlaj-Perez, in addition to financial constraints and the lack of access to counsel, not to mention, I imagine, a lack of ability to read English. Insufficient? Federal litigation is for the rich, after all, in America. Bless you, pro bono lawyers. And it'll rarely win the day for equitable tolling, that is, all the things I just said. Moreover, Mr. Oxlaj-Perez, quote, presents no details about his legal consultations, so he has not established that he acted diligently during the 79 days before he filed his petition for review, end quote. And of course, the government is prejudiced by extending the time it takes to remove a human. Meaning that for all of those reasons, and despite instituting a decent legal rule, Mr. Oxlaj-Perez lost his case. And that is Oxlaj-Perez v. Blanche. Continuing on, we have De v. Blanche, published by the Sixth Circuit on April 29, 2026. This case is about motions to reopen and mistranslations. Mr. De is from Mauritania, and it appears presented himself at a port of entry in an effort to seek asylum. He lost in immigration court, testified at 3 separate hearings, testified he was literally a slave in Mauritania. He said he'd been arrested in his Form I-589 and tortured, but he testified he had never been arrested. The immigration judge believed that and other things were too inconsistent and denied based on adverse credibility finding. Mr. De did not appeal, but eventually moved to reopen after learning that the literal court-appointed interpreter on his case had later been disqualified as an interpreter in immigration court. So that's not nothing, right? The language is Fulani, by the way. In his affidavit in support of his motion to reopen, Mr. De testified that he had some issues understanding the interpreter at the 3rd and final hearing. The IJ denied the motion to reopen and the BI affirmed, as did the Sixth Circuit. Quote, for starters, Mr. De can't point to any specific mistranslations or mistakes by the interpreter at the 3rd hearing, end quote. So that's a problem. That makes Mr. De's allegations too vague and speculative to succeed on a motion to reopen. While it may be difficult to pinpoint direct mistranslations, well, Mr. De could get the transcript and audio of the hearing, reasoned the Sixth Circuit. Could he, though? Would a transcript be provided with a motion to reopen appeal? I don't think this is an ECAS case, so no immediate audio available either. And while the audio can be obtained through an EOI or FOIA, that could take over a year, meaning Mr. De would then run into timeliness issues on a motion to reopen, I'd think. Just saying. And regardless, quote, aside from failing to point out translation errors, Mr. De hasn't explained what he meant to say at the 3rd hearing, end quote. And then, of course, we've got inconsistent testimony, apparently from hearings 1 and 2 as well, where there is no alleged translation issue. The stuff about beatings where he lived and the inconsistency about arrests and torture all predate the 3rd hearing and all not good to the Sixth Circuit. Not to mention, apparently, even an inconsistency about whether his brother was alive or dead. And yikes.com on this statement from the court, quote, beyond the contradictions, there's another reason why Mr. De is incredible. Mr. De claims that he fled Mauritania to escape persecution, but he traveled through several other countries without seeking asylum before reaching the United States. Mr. De's failure to seek asylum from any country that he passed through on his way to the United States significantly undermines his claims for asylum, cat protection, and withholding of removal, end quote. Yikes.com. It all meant no due process violation to the court as well. Quote, proceedings violate the due process clause only when they are so fundamentally unfair that the non-citizen was prevented from reasonably presenting his case, end quote. The Sixth Circuit sees that as an extreme standard. Interpretation issues could meet it, but it might actually require a showing that the IJ knew that the interpreter was not accurately translating and then didn't correct the issue, which is a pretty hard burden to meet. Plus, Mr. Den never objected during proceedings. Kind of hard to do that if you don't have your own personal interpreter to make sure that the court's interpreter is doing it right, but a factor nonetheless for the Sixth Circuit to consider. Deeming it without jurisdiction to consider some other issues, the Sixth Circuit affirmed denial of the motion to reopen. And that is De v. Blanche. Finally, from the April 29th publications from the Sixth Circuit, we have Us v. Blanche. By the way, the last name is U.S. Us or Us? Unsure? Gonna go with Us. This case is about exceptional and extremely unusual hardship. No court sees it for Mr. Us's children and so denied his non-LPR cancellation of removal application. He's from Guatemala and has lived in the United States for 25 years. Seems like he's a good guy. First, how should the Sixth Circuit review this hardship question? The standard of review issue post-Wilkinson. Like all courts before it, except one, I believe, the Sixth Circuit has picked substantial evidence review for this fact-intensive, mixed question of law and fact. Relying on Urias-Oriana v. Bondi from this term at the Supreme Court, by the way, which I must say I did call. If you want to go back and check me on that, go back and check me. Not even going to give you the episode. You got to look for it. That means that the BIA's quote determination that a given set of undisputed facts does not rise to the level of exceptional and extremely unusual hardship is conclusive unless any reasonable adjudicator would be compelled to conclude the contrary, end quote. High standard and unmet here to the Sixth Circuit. 2 U.S. citizen children, but exceptional, extremely unusual hardship means that the harm of the non-citizen's removal must be significantly different from or greater than the hardship that a deported non-citizen's family normally experiences. That latter stuff was a quote that I forgot to quote. It's a difficult burden for non-citizens, explains the court. In this case, I believe that the increased financial burden on the family is common and okay under U.S. immigration law. And if they all moved to Guatemala, the parents could get jobs and they could sell their home and vehicles in America. As to the educational and medical hardships that the kids will face in Guatemala, a, quote, lower standard of living, end quote, doesn't cut it, explains the court. Looks like the claim is that the kids will join, by the way. Quote, although Mr. Us's children do not have any cognitive issues, learning difficulties, or serious medical conditions, if those needs did arise, the children would return to the United States for related treatments, as the IJ noted, end quote. As to the violence and other poor conditions in Guatemala, that is a factor, but insufficient to move the needle here. The Sixth Circuit also believes that the agency reviewed all hardships in the aggregate, as the agency must. Judge Cole concurred to note that actually, quote, there may be circumstances in which a child's removal to a country known for violence and high crime rates, such as Guatemala, would qualify as an exceptional and extremely unusual hardship, end quote. Just not here. And that is Us v. Blanche. My final case of the week, I think, is Hannon et al. v. USCIS et al., published by the Ninth Circuit on April 27th, 2026. This is a case about I-130 petitions, and it is long. I'll be as quick as I can, but it's a long one. Mr. Hannon is from Israel and entered the United States on a tourist visa. He married Miss Gullum, and their marriage is totally legit. She's a U.S. citizen and filed an I-130 petition so he could adjust to LPR status. Problem is, Mr. Hannon has been married before. A year and a half after he overstayed his visa, he married, and that marriage was to a Margarita Jaime, who is also a U.S. citizen. That was a fraudulent marriage, done only for immigration papers. Or at least that's what Miss Jaimes would later tell USCIS in a sworn statement. Got paid to do it too, she alleged. They divorced less than 2 years later. The fraud allegation and sworn statement came out at Mr. Hannon's I-130 interview with his wife and counsel present. Nightmare, really. They were given 20 minutes in a secure room to prepare their rebuttal, and Mr. Hannon created a statement in very little time, swearing it was a legit marriage, with details, lots of them, really. And here's the thing. It is undisputed that Miss Jaime never filed anything for Mr. Hannon. Nothing. From where USCIS sits, they simply got married and then divorced. No attempt for immigration paperwork. Still enough to reach an I&A Section 204C finding and bar Mr. Hannon from adjustment of status forever, notwithstanding his current bona fide U.S. citizen family. Lots of evidence, too. I've skipped it all, including some other stuff, though, that USCIS had that it believes showed a fraudulent marriage. I'll get to that in a sec. But Mr. Hannon appealed to the BIA as the law provides, which affirmed the USCIS adjudicator. Life ruined, he and his wife sued in federal court, where he lost. And the Ninth Circuit affirmed that. Mr. Hannon's primary argument was that the marriage fraud bar in I&A Section 204C isn't triggered if the non-citizen and spouse literally don't do anything and don't try to get any immigration benefits or anything. Query what unwaivable lifetime bars you would be subject to, dear listener, if the worst mistake you ever made was known, even though you didn't act upon it and fixed everything before anything else happened. The problem for Mr. Hannon is that the statute Congress wrote at I&A Section 204C reads as follows, quote, no petition shall be approved if 1, the non-citizen has previously been accorded or has sought to be accorded an immediate relative or preference status as the spouse of a citizen of the United States or the spouse of a non-citizen lawfully admitted for permanent residence by reason of a marriage determined to have been entered into for purpose of evading the immigration laws, or 2, the Attorney General has determined that the non-citizen has attempted or conspired to enter into a marriage for the purpose of evading the immigration laws, end quote. So, like, at a minimum, number 2 is really, really, really bad, broad, and cruel. Seems focused solely on the marriage and not doing anything with it from an immigration standpoint, right? What's more, the statute changed in 1986. It used to clearly require that a non-citizen obtain an immigrant visa for the bar to apply, and it clearly didn't apply to attempts. So Congress's change of the text to reflect what I just said was clearly intentionally to broaden the statute, explains the court. So Mr. Hannon's in trouble. Not to mention a DHS regulation making very clear that it applies in situations like this, although the Ninth Circuit puts that in an inconsequential footnote. Although excellent argument from Mr. Hannon's very smart counsel. If number 2 covers literally any false marriage, it completely subsumes scenario 1, making it redundant. Quote, a fair point, end quote, conceded the Ninth Circuit. But Congress is allowed to do that, especially when, as here, they're retaining part of an older statute and just kind of adding to it. Also, the Ninth Circuit thinks that subsection 1 and 2 focus on different things that might be easier to prove depending on the case, so not completely redundant. In any event, the statute is unambiguous, so that's kind of the end of it. The canons of statutory interpretation cannot supersede the plain text. So too with legislative history. Plus, the BIA has interpreted the statute to cover mere agreements to marry for papers since 1988. Matter of K. Although more recently, matter of R.A. Ortega would require an overt act for the conspiracy portion of Section 204C to apply. But in any event, the Ninth Circuit believes the marriage itself would qualify. That's an overt act. Losing on the statute, Mr. Hannon and his second wife alternatively argued that USCIS violated their due process rights by relying on this alleged sworn statement without permitting Mr. Hannon the opportunity to cross-examine Ms. Jaime. That means the Ninth Circuit applies the well-worn due process test explained in Matthews v. Eldridge. It also means we're going to discuss the very important Ninth Circuit decision from 2013, Ching v. Mayorkas, 725 Fed 3rd, 1149. The Ninth Circuit sees the process provided here due. Let's talk about Ching. To the panel, Ching held that the I-130 petitioner has a protected property interest in the approval of an I-130. So that's good. But then the panel began to distinguish Ching. The second Matthews factor is about process to protect the risk of erroneous deprivation, and in Ching there was lots more evidence that the marriage was bona fide. Also a much shorter statement from the ex-partner. And USCIS only provided one opportunity for the non-citizen to respond with their evidence, I guess annoyed, whereas here Mr. Hannon was provided 4 opportunities, noids and RFEs, and I guess that statement in the room. Now it's true, and something that I say all habeas warriors should remember, quote, due process generally requires that an agency give serious consideration to evidence that facially supports a claim, end quote. Great quote if you get, say, a pretextual bond hearing after a habeas one. But here the court sees it met. The ex-wife's statement wasn't the only thing relied on. Mr. Hannon made statements to investigators in a completely unrelated thing that made it into the record that USCIS sees as corroborating his ex-wife's fraud allegation. Going to get to brass tacks here because Ching is really an important decision. Quote, crucially, unlike in Ching, plaintiffs here provided no substantial evidence that Mr. Hannon's first marriage was bona fide. Plaintiffs argue that Mr. Hannon's undisputed request for Ms. Jaimes to move to San Francisco is not consistent with a marriage entered into solely for immigration purposes. But plaintiffs provide no evidence that Mr. Hannon and Ms. Jaimes lived together in Los Angeles or would have lived together in San Francisco. Mr. Hannon's declarations conspicuously omit such representations. Mr. Hannon referred to his residence in Tarzana as my apartment, and while he asked Ms. Jaimes to move to San Francisco with him, it is unclear that he intended for her to live with him there. Plaintiffs provided no evidence of joint tenancy or commingled financial resources. End quote. Important for cases like this. And in light of everything that's already happened, the Ninth Circuit doesn't think more process would really move the needle. Crucially to me, quote, even if cross-examination of Ms. Jaimes undermined her credibility, the state investigative report in which Mr. Hannon admitted to paying Ms. Jaimes to marry him in exchange for immigration benefits provided independent evidence of marriage fraud. End quote. I've kind of flicked at this. There's another investigative report, completely separate from the state of California, from a gambling matter, I believe, that's really screwing Mr. Hannon here. The final Matthews factor is about burdens to each party. Here the government by requiring cross-examination of an ex-wife. Ching simply required another hearing or maybe an interview, explains the panel. And unfortunately for immigration litigators everywhere, but especially in the Ninth Circuit, quote, given the nature of marriage fraud, USCIS will frequently rely on statements by a former spouse, requiring the agency to hold an evidentiary hearing in every such case, regardless of the circumstances, would impose substantial costs. End quote. So Mr. Hannon failed Matthews and got no more procedure. Finally, then, was the evidence before USCIS sufficient for USCIS to get summary judgment before the district court? It was. Overwhelmingly so, actually. It's an Administrative Procedure Act challenge, right? So not overwhelmingly that the 204C finding should be made, but overwhelmingly that it wasn't arbitrary and capricious to the court. First, the ex-wife's sworn statement that it was marriage for papers and she was paid. Then there's that California investigative report thing. And in a vacuum, actually, the Ninth Circuit doesn't see Mr. Hannon's evidence as overly persuasive, particularly given that the supporting family statements provided were conclusory. To the extent the BIA missed some evidence on appeal, well, it need not address every single piece of evidence. Well-researched and litigated case, though, on this important issue, but a tough decision. And that is Hannon et al. v. USCIS et al. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America.
Hello, everybody. This is Homero Lopez. I'm back at, I'm pretty sure, nobody's but Kevin's insistence. I'm here to cover the remaining cases for the week as Kevin takes a little bit of personal time, much deserved. And we have two cases, one from the 7th and one monster from the 1st. So I will start with the one from the 7th. Cuatl Chiquito versus Blanche, published by the 7th Circuit on April 30th, 2026. This case is about motions to reopen. a second decision this week from the 7th on motions to reopen. Okay, then, let's do it. Ms. Cuatro Chiquito entered the U.S. without inspection on September 26, 2024, and was not immediately apprehended by DHS. The 7th doesn't tell us where she's from, but I guess it doesn't matter in this case analysis. A few days after entering the United States, she was in a car accident where a semi-truck hit the vehicle in which she and 15 other migrants were traveling. Must have been a pretty severe wreck since 2 of the passengers were killed as a result. Very tragic, and makes me wonder if Ms. Cuatro Chiquito might be eligible for a U visa. Maybe? We'll see. After the accident, Ms. Cuatro Chiquito and the other survivors were taken to a local jail and questioned by the local police. No hospital trip? Maybe the 7th simply didn't mention it or didn't find it relevant. Who knows? Nonetheless, after being questioned by the local police, Ms. Cuatro Chiquito was turned over to DHS officers who apparently took down an Indiana mailing address for her. DHS personally served an NTA with the infamous to-be-set date and time. Remember, this is 2004. A month later, the immigration court mails her a notice of hearing to that Indiana address and sets her initial hearing date for December 29, 2004. Ms. Cuatro Chiquito claims she never received the notice because she never resided at the Indiana address and instead had gone to live in Columbus, Ohio right after the accident. As a result, she missed the hearing and was ordered removed in absentia. Fast forward a few years, and the Supreme Court issues its Becerra and Nis Chavez decisions, episode 53, for Nis Chavez, that is. This illustrious podcast was not yet operating when Becerra was decided. How did we practitioners ever keep up in the before times? Due to the holdings in those decisions regarding defective NTAs, Ms. Cuatro Chiquito filed a motion to reopen, which was clearly time-barred. But Ms. Cuatro Chiquito requests the deadline be equitably told as a result of Nis Chavez and, alternatively, that the court exercise its sua sponte authority to reopen. Good argument, but the IJ denied, finding Nis Chavez did not toll the statutory deadline and declining to exercise sua sponte authority to reopen. So she appealed to the BIA. While the appeal was pending at the BIA, Ms. Cuatro Chiquito files a second motion to reopen with the BIA, arguing, for the first time it appears, that she was never provided with a notice of hearing. That changes things because such an argument would exempt Ms. Cuatro Chiquito from the statutory deadline for motions to reopen. See 8 CFR sections 1003.2C2 and 1003.23B4 little Roman numeral 2. Her argument here was based on DHS officers not speaking Spanish, her not understanding the documents she signed, and her never having resided at the Indiana address. Makes me question, did she ever give that address to the DHS officers? Were the other 13 migrants who were in the accident also being questioned by DHS at the same time? Was she injured? Was she ever provided with any medical assistance after what seems to have been a pretty intense car accident? I have so many questions. Nonetheless, the BIA affirmed the IJ's order, specifically finding that Nis Chavez did not toll the deadline to reopen because the defect on the NTA was ascertainable when she was personally served with the notice in 2004. And Ms. Cuatro Chiquito had not explained how she had diligently pursued her claim in the intervening years. The BIA does love diligence. Insider tip right there. Regarding the second motion to reopen, filed directly with the BIA, the one which argued lack of notice, that one was found to be numerically barred as the statute only allows for one motion to reopen. Alternatively, the BIA also denied the second motion to reopen on the merits, finding that she had not established lack of adequate notice. Alternatively, the BIA also denied the second motion to reopen on the merits, finding that she had not, quote, established lack of adequate notice, end quote. In doing so, the BIA noted that there's, quote, no requirement that her NTA be written or explained to her in Spanish, and reasoned that, having failed to provide a valid address to the immigration court for purposes of receiving notice, she was not entitled to actual notice of her removal hearing, end quote. Now that's kind of wild. The BIA seems to have made a factual finding there in saying that she didn't provide an address to the immigration court, although it seems to me that Ms. Cuatro Chiquito is contesting having provided that Indiana address at all. But what do I know? I'm just a substitute podcast host for part of this week. Finally, the BIA was not persuaded to exercise their sua sponte authority. The BIA is really covering all their bases here. On to the 7th. In her appeal to the Seventh Circuit, Ms. Cuauhtémoc-Chiquito had 3 arguments, and the Seventh Circuit took them in turn. First, the Nice-Chavez equitable tolling argument. The Seventh Circuit has held that the time and number bars to motions to reopen are, quote, non-jurisdictional claim processing rules subject to equitable tolling, end quote. And such tolling requires the petitioner, quote, to show that she has been diligent in the pursuit of her rights and that an extraordinary circumstance blocked her path, end quote. The extraordinary circumstance Ms. Cuauhtémoc-Chiquito puts forward is the Nice-Chavez decision and argues she acted diligently upon its issuance. The Seventh disagrees. While the Seventh Circuit hasn't addressed this specific issue, it finds it analogous to the post-Pereira case law where it rejected, quote, near identical equitable tolling arguments, end quote. The Seventh Circuit, quote, sees no reason to treat Nice-Chavez any differently, end quote, than Pereira, and agrees with the BIA in finding that, quote, Nice-Chavez did not change the fact that Ms. Cuauhtémoc-Chiquito could have raised her challenge to the NTA at the time of her initial hearing, end quote. And in failing to do so, she did not act diligently. Next, the Seventh addressed the denial of the second motion to reopen due to the numerical bar. Here, Ms. Cuauhtémoc-Chiquito argued that both the time and the number bars were not applicable under 8 CFR section 1003.23 B4 small Roman numeral 3, capital A, 2. This, however, is the wrong regulatory framework, says the Seventh. 8 CFR section 1003.23 B4 3A2 addresses orders in absentia in deportation proceedings. Meanwhile, Ms. Cuauhtémoc-Chiquito was in removal proceedings. Therefore, her motion to reopen is governed by 8 CFR 1003.23 B4 Roman numeral 2. The former excuses both the time and number bars for in absentia orders, where there's no notice, but the latter only excuses the time bar. This is a change made in the IRA. As such, the BIA's denial based on the number bar was upheld. Last, the Seventh Circuit denied Mrs. Cuauhtémoc-Chiquito's argument regarding the BIA's abuse of discretion in failing to exercise their sua sponte authority. The Seventh notes that their, quote, jurisdiction to review the board's refusal to reopen a proceeding sua sponte is narrow, end quote, requiring, quote, constitutional transgressions, end quote, or other legal errors. In denying sua sponte reopening, the BIA noted that they had, quote, cumulatively considered, end quote, Ms. Cuauhtémoc-Chiquito's claims. That reference to cumulative consideration leads the Seventh to take into account the rest of the BIA's reasoning, even if not expanded on specifically regarding the sua sponte argument. So, the Seventh denied Ms. Cuauhtémoc-Chiquito's petition for review, and her order for removal remains in place. And that's Cuauhtémoc-Chiquito v. Blanche. Like Michael Corleone, just when I thought I was out, the First Circuit pulls me back in. Next, we have Usma Acosta versus Blanche, published by the First Circuit on May 1st, 2026. This one is a monster. This case is about literally everything. Seriously, it's wild, so buckle up. The First Circuit notes that counsel and the government all reference the petitioner here as Mr. Acosta, so I will follow suit. Our saga begins with a man named Carlos Alberto Rendon Castañeda, for whom the first simply uses Rendon. Mr. Rendon entered the United States on May 5th, 1995. Hey, that's exactly 21 years from when this pod will be posted. What a coincidence. The First Circuit doesn't say, but it would seem he entered with a visa of some sorts. He went to live in Massachusetts, where he met Ilandia Neuta, and they married in 1998. Mr. Rendon adjusted status through his wife. They had a son whom they raised together and sent to college, and he became a nurse. By all accounts, they seem to be living a regular suburban life. In 2020, however, Mr. Rendon, at the encouragement of his son, applied to naturalize, and that's where we get a major plot twist. Mr. Rendon was scheduled for and went to his naturalization biometrics appointment. As a result of what the First Circuit calls, quote, a complex cross-referencing fingerprint analysis, end quote, USCIS discovered his true identity. Mr. Rendon was actually Mr. Acosta. I told you it was a wild one. Here's the backstory. Mr. Acosta was born in Colombia. There he met and married his first wife, a woman named Laura, with whom he had 2 children, Jennifer and Christian. According to Mr. Acosta, there are some credibility and conflicting accounts, which we get into a little bit later. Laura's mother and brother didn't like Mr. Acosta because he grew up poor. Mr. Acosta worked as a waiter and taxi driver, struggling to make ends meet. Meanwhile, Laura's brother was involved in the drug trade and offered Mr. Acosta to join him. Mr. Acosta, quote, always refused, end quote, but not his wife, Laura. This situation caused a tension in the marriage, which led to their separation. After the separation, Mr. Acosta spent the weekends with his son and daughter. Now, the plot really thickens. In June of 1994, Mr. Acosta went to pick up his children from Laura. His daughter decided to stay with her mother, so Mr. Acosta only took their son. Soon he returned to Laura's house because his son had forgotten something. As he approached the home, shots were fired at Mr. Acosta and he fled the scene. He dropped his son off with his mother, grabbed a gun, and returned to Laura's house to get his daughter. Upon return, quote, tensions flared, end quote, and Mr. Acosta shot Laura and his daughter. Laura died, his daughter survived, and Mr. Acosta went into hiding, fearing that Laura's brother would come after him. Mr. Acosta obtained a false ID with the alias of Mr. Rendon and came to the U.S. and lived the next 30-plus years as described earlier. While he was living in the United States, Mr. Acosta was convicted for aggravated homicide, attempted aggravated homicide, and illegally carrying weapons of personal defense and sentenced to 28 years of prison in Colombia. All of this in absentia, apparently. That conviction led to an Interpol red notice being issued, and that's what showed up for USCIS when they ran Mr. Acosta's fingerprints. So, on April 13th, 2022, ICE agents show up at his work to arrest him and charge him as deportable under INA Section 237A1A as someone who was inadmissible at the time of entry or adjustment of status. The government argues he was inadmissible under INA Section 212A6CI for having procured his status through fraud or willful misrepresentation of a material fact. The government argues he was inadmissible under INA Section 212A6C, Roman numeral 1, procured his status through fraud or willful misrepresentation of a material fact. Specifically, the government focuses on his false identity and his failure to disclose past marriages on his adjustment of status and naturalization applications. Given the, quote, quirkiness of immigration law, end quote, how quirky and cute. The First Circuit provides us with a 5-page primer on immigration procedure, asylum, withholding of removal, CAT, waivers of inadmissibility, and cancellation of removal. Now you can see why I said this case was about everything. Let's dive in. Mr. Acosta denied the allegations and charges against him and, quote, the government figuratively threw a pile of papers at him, end quote, including fingerprint reports, his immigration applications, Colombian criminal records, and the Interpol red notice. With this evidence and apparently some concessions from Mr. Acosta and counsel regarding his false identity, the IJ found him removable. As such, Mr. Acosta applied for asylum, withholding, relief under CAT, a waiver of inadmissibility under Section 237A1H, and cancellation of removal for permanent residence. Given the various forms of relief being sought, the IJ understandably held various hearings over several days, but eventually denied all of Mr. Acosta's applications and ordered him removed. Apparently, DHS even brought Mr. Acosta's daughter from Colombia to testify against Mr. Acosta. That's wild. In my 15 years of practice, I have never had DHS bring any witnesses, even when the court subpoenas the officers. Apparently, there was a previous appeal to the BIA after the IJ's decision, which remanded the IJ to specify which findings of fact were relied on to establish removability, informing the IJ to apply First Circuit, not Fourth Circuit law, reassess credibility, and take another look at the CAT claim. Whew, this IJ really had their work cut out for them. After remand, the IJ again denied all relief, and Mr. Acosta again appealed to the BIA. The BIA cleaned up the IJ's decision a little, but generally affirmed. The First Circuit also affirmed in a very thorough decision. The IJ found Mr. Acosta procured his status through fraud and willful misrepresentation, both as to his identity and marital history. For identity, the IJ relied on Mr. Acosta's own paperwork, the fingerprint reports, and his asylum application. At the circuit, Mr. Acosta challenges this last one as being inappropriate fact-finding since the application was filed after removability was established. And the First Circuit agrees, but since the BIA did not rely on that IJ finding to uphold the removability finding, it wouldn't make a difference to the outcome. For the marital history, the IJ also relied on the previous applications where there were different spouses listed on the adjustment and naturalization applications, and never did he disclose his previous marriage to Laura. There's still a lot to go here, so I'm not going to get into the weeds on the credibility findings. Suffice it to say that the IJ found Mr. Acosta and his current wife not credible due to too many inconsistencies and discrepancies, but found Mr. Acosta's daughter credible, and her testimony was supported by corroborating evidence. When it came to asylum and withholding of removal, the IJ found serious reasons to believe Mr. Acosta committed a serious non-political crime when he murdered his first wife, Laura. The first goes on to explain that they have, quote, equated the serious reasons standard to probable cause, which itself means there's a fair probability, end quote, and that, quote, the standard does not require either certainty or an unusually high degree of assurance, end quote. Here they cite their precedent in Morgan v. Garland, episode 237. This finding statutorily bars Mr. Acosta from both asylum and withholding. This leaves Mr. Acosta with cat deferral, which the IJ denied because he did not show it was more likely than not that he would be tortured at the instigation of or with the acquiescence of the Colombian government. The First Circuit agrees with the IJ and the BIA that Mr. Acosta's country conditions filings were generalized and did not corroborate his claim. The first believes the IJ did consider all evidence regarding the, quote, unsubstantiated threats, end quote, and properly found no connection between whoever was making those threats and the Colombian government. Further, Mr. Acosta argued he'd be subjected to arbitrary arrest if returned, but the IJ, the BIA, and the First believe his criminal conviction in Colombia means the arrest will not be arbitrary, but instead a legal sanction. Last, Mr. Acosta argues the Colombian government, quote, targets people like him, end quote, but doesn't explain who people like him are. The First doesn't believe Mr. Acosta has, quote, shown he personally faces a risk of torture, end quote. That's from Urias-Orellana v. Garland, episode 238. As such, Mr. Acosta's cat claim is denied. Moving on to the inadmissibility waiver and cancellation of removal claims. This case really is never-ending. Good effort, counsel. On both of these issues, the IJ did not get to the question of whether Mr. Acosta qualified for the relief, but instead denied on discretion after engaging in a balancing test of the equities. Mr. Acosta has many positive equities: family ties, long residence in the U.S., work history, hardship to his family, and a lot of letters of support from the community. However, the long-standing identity fraud, which led to him obtaining his immigration status, and his Colombian criminal conviction were too much for the IJ to overlook. As such, the IJ denied the waiver of inadmissibility and cancellation of removal on discretionary grounds. The First Circuit finds, quote, a jurisdictional size obstacle sitting between us and any meaningful review, end quote, of the IJ's discretionary decision since they, quote, have held 8 U.S.C. section 1252 A2B Roman numeral 2 strips us of any jurisdiction to review discretionary decisions about waivers of inadmissibility, end quote. The First points out that Patel also makes it clear that not only is jurisdiction stripped in reviewing the granting of relief itself, quote, but also any judgment related to the granting of relief, end quote. Patel strikes again. As such, the First says it has no jurisdiction to review the denial of the waiver of inadmissibility. That same analysis is applicable regarding cancellation of removal, so that's out too. The First does note, however, that Patel did leave them with jurisdiction to review constitutional claims and questions of law. Hey, gotta take a win where you can get one, right? But since neither of those are present here, they remain without jurisdiction. And you thought that was it, right? Well, you're wrong. Apparently, Mr. Acosta also brought a motion to reopen before the IJ. Must have been sometime before he filed the appeal? It's unclear. The motion was accompanied by affidavits from his sisters regarding Mr. Acosta's credibility and attacking his daughter's credibility. The IJ denied the motion, finding that the sisters' affidavit would not change the outcome. The First Circuit agrees. They remind us of the high standard of review for denial of a motion to reopen and explain that the new evidence must be material. Here, the first doesn't see how it would be material, particularly since it actually contradicts some of Mr. Acosta's own testimony. Ouch. Thus, not affecting the IJ's original credibility determination. As such, the first rejects Mr. Acosta's argument on the motion to reopen. There was also a discussion regarding IJ bias, but the First Circuit did not see it, and from the limited record citations were provided, neither did I, so I'm not going to delve into that part too much, given how long this decision already is. And that's Usma Acosta v. Blanche. All right, what a week. Thank you for indulging me. Next week, you'll have Kevin back, and he'll be covering a case from the Ninth Circuit that came out this week, Sanchez-Gonzalez v. the U.S. Department of State, because he has a soft spot for the doctrine of concern non-reviewability, and he really wanted to do it. That's it for me. I'll see y'all next time. Have a great one.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Aww. Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.